for admission, item 1.
The petitioner has attributed the voter list to 1970, including the field part in 1970. Yes, Your Lordship. Please, Your Lordship, move on to page 19, the vernacular voter list, Your Lordship. Annexure 1 of my petition, Your Lordship. The last name, Your Lordship, serial number 177, Your Lordship. Page number 19. 18 is the translated copy, 19 is the vernacular one. Nur Hussain, son of Azimuddin, and his village is Goburi Guri Pathar, Moja Khari is his name. So, Your Lordship, they continue to stay in the same place, only there is some variation in name. Sometimes Hussain become Haq and or Islam. But even if Your Lordship move on to page 22 now, which is the voter list of 1989, page 23. Your Lordship, here, my father's name become Nurul Haq, but my grandfather's name is still Azimuddin. And the village is the same village, Your Lordship. Boholi. Here, Your Lordship, my mother's name also appears in page 23, Your Lordship, serial number 519. Her name has been printed as Auzan Khatun instead of Atobjan Khatun, wife of Nurul. And my name is along with them, serial 522. It has been shown as Siras Fakir. But in the voter list of 1997, Your Lordship, page 25. Lordship, sorry. Yes, sir. Khatun, in the voter list of 89, it is Auzan Khatun, but in the voter list of 97, it becomes again Atopjan Khatun. Page 25, your Lord. My father's name become Nurul Islam, mother's name Atopjan Khatun. My name now becomes Siraz Ali. So, your Lordship, there is a constant typographical error in the voter list, your Lordship. But similarity in the voter list can be drawn because the same people's names continues in the same village. Similarly, your Lordship, in the voter list of 2008, my father's name is shown as Nurul Islam, my mother's name Atabzan Nessa, and my name is shown as Sirajul Haq. Lordship, is 43 to 46. In the written statement, though I have mentioned about the voter list of 65 and 85, I couldn't produce it and exhibit it as evidence, your Lordship. But the voter list of 1970, 89, 97, 2011, all were mentioned, your Lordship. And regarding the variation of the name of my father, your Lordship, I was given a statement, your Lordship. Lordship. Exhibit J. Your Lordship, this was a piece of land that has been purchased by my father. In Lordship. J. Your Lordship, in the order, Your Lordship, page 66, it has been written, Your Lordship, in serial number 8, Exhibit J, photostat copy of a sale date, which is proved in original copy. In page number 66, impugned order. So you can meet it. You can agree with you. Yes, sir. Up to K law. Up to K. Tell it. Tell it, look. Yes, and give one question. Yes, doctor. Agree with you. Yes, doctor. Again, Jamabondi copy, it was again matter. I agree with you. Agree with you. 1965. Totally. L. L. Okay, 4 witnesses. Oh, here also I. Up to I. EW2 up to exhibit I. Yes. EW. Moving something, moving on.
Definitely, my lord. But then in this record, my lord, I have gone through the documents which are exhibited, shown to be exhibited, which are signed, is the my lord, earlier member. Yes, the earlier. Definitely. Exhibit A is no, my lord. I don't know, my lord. It may be someone else. That is not. But my understanding is that when your lordship is looking up the cases, you have to look the trial court because trial court records. Definitely, you have to look the trial court records because yes. If everything is there, then it's a different issue. But we have to go through the method. Otherwise, it may cause. Yes, ma'am. My submission in this case, my lord, I think, my lord, there are some. I don't know what is the internal issues here, my lord. So let me go through. Let us make it our inquiry ourselves. What is the issue here? Because one thing is there, my lord, with regard to exhibit A's, the preceding, my lord, next the member, succeeding member, he has said that it exhibit A's is not in the record. When he can point out this particular exhibit, that he has on 30/2018, he has said that OP is present along with his engaged advocate and he has filed a petition by so stating that he has exhibited a Gauhati certificate on exhibit Ace in his evidence in six, but exhibit Ace is not available in the record. That he has found, but other documents which are there, which are not. Yes. 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 No, definitely, my lord. That's why, my lord, I'm not saying there may be. I'm not saying that there is foul play, my lord, but there may be, my lord. That's why. Yes.
What is there in the issue set and what is there in the evidence, what is there in the procedures, and what is there in the
Yes, yes.
opinion? And then we look at the documents.
It is true, my lord. That's my lord. I admit that while keeping the records, arranging the records, there is no proper procedure. So we have made an SOP as on now, my lord.
Right.
Yes, no,
This member.
these are records of my lord 2018-19. That is the problem, my lord. Now, yes. Let us make an inquiry ourselves first, my lord. Then your lordship may first, my lord, because we need an inquiry in this regard, because whether the documents, my lord, which are next herein were originally exhibited by the yes, signature of the presiding officer, my lord. That's right. And why, my lord, these things with even the signature is there.
There is some evidence that is there.
Yes, there should have been evidence. That's why I'm saying, my lord, there is no evidence that, my lord, the documents were even and in the, my lord, order sheet I have not seen. Yes, in order sheet I have not seen. Yeah, in the cross examination also it is not there. In the evidence it is not there. How this document has come to this record?
Right.
Exhibited. Yes. Yes. Let us have an own inquiry, my lord, first, then your lordship first.
On this, all the vigilance inquiry also.
Yes, ma'am.
That's we have to read the entire history and then using. We are not doing it. I mean, you can take over you maybe a chair and etc.
Yes.
We actually try to record in this thing happens. Not the meaning. It's the question. Yes, strategy is strategy and that's. Because if I need a market there is.
Or otherwise, your lordship may remand it, my lord, will make an inquiry or something. No, my lord, you. Yes.
Just say that the continued utility of the software takes.
Then first of all, let me make an inquiry, my lord.
Then this will follow in every order. We all will take up.
Yes, we go. Will that take you or not? Yes. Yes, ma'am. May I take this, my lord, record?
Yes.
Exhibit H, my lord.
Abul Kalam Azad, your lordship is the brother-in-law. Brother-in-law of the opposite party, the petitioner.
What I want, there is a recommended order sheet, in the order sheet, there is recorded below. Yes.
This, with the ACL now less now. Unless you compare this to the documents, the evidence and then we use to state. Because he, the family. What's the writing?
Yes. But that's why, madam, how it has come.
After finding out that there is actually there is nothing included, you cannot see it.
No,
Whatever
madam,
you would have said, there is in the documents, some other document is granted as dash. That you guys, what a mistake.
what I wanted to show you also, on 30/2016, 18, the court has recorded the exhibit certificate, government certificate as exhibit A's according to them.
He said that.
Yes.
But the, that executed document, his name is say,
Yes.
that's not right. Remember, right, that the agreement is not there. If you have said that the governments are not in the wrong.
I am not protected my petitioner. What she is saying, the exhibit is according to them, madam. There are two, one exhibit is according to them, it is what I wanted to show you.
Understand?
Yes.
Fine.
Yes.
But let us say we are right.
Yes.
Right? We have evidence.
Yes.
Right? There are evidence. Now let us say that there is an old record, problem document is back there. We will know.
The whole document has to be existed.
So we have the record that then.
Yes.
These are the correction. And change the party what to describe that.
Oh, probably he has not changed, but we exhibit is another. You are not doing it. Oh, we just. The next one is not signing. Yes, there is a marking, but that next one is not signing. It was exhibited by her sister, doctor, his sister. Again, exhibit A, B, C. Yes, sir. Yes, yes, yes. No,
documents will be the statement will be evidence. And then depending on the way.
what I wanted to show you, why I'm suspecting the record. That's why that point I wanted. What the on 38/2018 it is recorded. Article advocate for the petitioner on perusal of case record. It is found that the exhibit is available. Earlier it is said exhibit is available in the case record, but it is not the Gaungura certificate. Though it is evidence in safe. That's because so he has stated that exhibit is a residential certificate issued by the Gaungura. He has exhibited a photocopy of his birth certificate as exhibit A. That is there. That is there. Along with the evidence in safe. Contents of the petition number so and so is not found to be correct. So prayer rejected. So exhibit A is what their contents is exhibit. That's why I'm saying, they are saying this is some other exhibit. That's yes. That's why this exhibit is exhibit is.
You see, there is no evidence it will be established.
Yes, yes. No, that is, I'm not on merit, but it is only record, case record, orders it, not in the judgments, not in the opinion. Exhibit is birth certificate.
Home Department lordship and in the order, all these things may be making observation lordship regarding all these things lordship.
That cannot be done.
Petitioner also had so and so for the respondents. In course of hearing, the court had perused the records of the tribunal. And on examination of records, it is seen that in the evidence on affidavit filed by the petitioner Siraj Ali as DW1, he has exhibited $12 documents. No, 11 documents. No, 12 documents, out of which 2 documents are referred to as Exhibit J. For the sake of convenience, the documents which were exhibited are referred below. Number one, annual Khiraj Patta within bracket Exhibit A. Voters list of 1970 within bracket Exhibit B. Voters list of 1989 Exhibit C. Voters list of 1997 Exhibit D. Voters list of 2011 Exhibit E. Voters list of 2017 Exhibit F. EPIC, EPIC, EPIC. Electoral voter identity card. Exhibit G. Residential certificate issued by the Gambura. Exhibit H. Affidavit of name correction. Exhibit I. Registered sale deed. Exhibit J. Birth certificate of Sahina, Sahina, Sahina Khatun, Ahatun, within bracket Exhibit J. Rohan Ali, within bracket Exhibit K. Stop. At page 48 of the record, the sale deed is marked as Exhibit J, and a copy of Jamabandi available at page 52 to 54 is also found to be marked as Exhibit J. In addition, documents exhibited documents referred above. DW Regia Khatun, REGIA, Regia Khatun was examined as DW2. Has marked has also exhibited few documents as follows. Annual Patta within bracket Exhibit A. Jamabandi within bracket Exhibit B. Voters list of 1965 Exhibit C. Voters list of 1970 Exhibit D. Voters list of 1985 Exhibit E. Voters list of 1997 Exhibit F. Voters list of 2008 Exhibit G. Birth certificate of DW2 Exhibit H. Certificate by Gambura Exhibit I. Birth certificate of Sahina Khatun Exhibit J. Birth certificate of Rohan Ali Exhibit A. School certificate of DW2 Exhibit L. Epic of DW2, Exhibit M. What is this of 2016? Exhibit I. As per the childhood records, certificate of birth issued in the name of Sahina Sahina Khatun is page 45 is which is marked as Exhibit H. If you think of Exhibit L, DW2, Exhibit L is AK, Exhibit K. Huh? H is it. H now, Exhibit I believe. DW2. H on the question again. On बोलो Exhibit H. Governor certificate Exhibit I. Huh? Exhibit I, that was J, K, birth certificate, L, school certificate, M, epic, I. On a perusal, on a further perusal of the records of the tribunal, the marking of document as exhibit are as follows. Annual Kiraj Pata, Exhibit A, within bracket, page 36. What is this of 1970? Exhibit B, page 37. Electoral roll of 1980, what is this? 1989, Exhibit C, page 38. 39. Notice list of 1997, Exhibit B, page 40. Electoral roll of 2011, Exhibit, what is this? Sorry, 2011, Exhibit E, page 41, 42. Epic of Shirajul, Shirajul of HAQE, Exhibit F, page 43. Birth certificate of Rohan Ali, Exhibit G, page 44. Birth certificate of Sahina, Sahina Khatun, Exhibit H, page 45. Affidavit, Exhibit I, page 46, 47. Sale deed, Exhibit J, page 48 to 50. Exhibit J, Jaman, Exhibit J, page 52 to 54. Voters list of 1965, Exhibit K, page 55, 56. Electoral roll of 1970. Voters list of 1970, Exhibit L, page 57, 58. Voters list of 1985, Exhibit M, page 59, 60. Voters list of 1997, Exhibit N, page 61. Voters list of 2010, within bracket Exhibit O, page 62. Birth certificate of Regia, EGI, Regia Khatun, within bracket Exhibit P, page 63. School certificate of Regia, REGI Khatun, Exhibit Q, page 64. Identity card issued by Gaungura for Regia Khatun, Exhibit R. Next. Next, the manner of marking of the documents as exhibit. It's compelled us to make an observation which make an observation that if this is the manner in which records of the cases are being dealt with, and the state government has not notified any SOP or a standard operating procedure for maintaining the records, specifically the exhibited documents. We pose a query to the state government, to the Home and Political within bracket B department, as to why in an appropriate case orders should not be passed to the state to examine the continued utility of those members who are unable to maintain records properly. Full stop. The exercise to find out the discrepancies in the marking of exhibits has consumed almost 1.5 hours of the court time. Full stop. We hope and trust that the state government would issue an advisory to all the foreigners tribunals to maintain records relating to the evidence and exhibited documents in a proper manner, and to ensure that the records are examined before before an opinion is expressed by the foreigners tribunals. We express our displeasure in the manner in which records have been maintained in this case. We also take note of the fact that in the in which order you said that by an order dated 30/8/2018, the learned member has made a reference to Exhibit H. However, we are surprised to note that though a document is marked as Exhibit H, which has been referred to in the order dated 30/8/2018, the said exhibited document finds no mention in the opinion dated 2012/2018. We are also disturbed, next paragraph, we are also disturbed by the fact that in the impugned opinion dated 12/12/2018, the learned member has referred to Exhibit A TO2, Exhibit A to Exhibit F, Exhibit I and Exhibit J. However, in course of its decision and reasons expressed in the said opinion, reference is made of examining Exhibit A, Exhibit B, Exhibit C, D, E, F, J, and I. Thus, the remaining exhibits Exhibit H and K11O PQ are which are found duly signed by the learned member in the draft of records have not been referred to. On a further perusal of the order sheet available in the tribunal's records, there is no order as to how additional documents could have been marked as exhibits by the learned tribunal. It is under these circumstances that the court is compelled to think that why the state government should not examine the continued utility of the learned members who You see, number one, compared to thing number one, why the state government does not give periodical training to the to the learned members as well as the UDA. The bench assistants are called UDA. UDA oblique bench assistant for proper upkeep of the tribunal's records. Comma, and number two, even despite training, if the learned members are not found to be maintaining the records as per the procedure established, why their continued utility should not be re-examined by the state government on a periodical basis, as is being done for all other state government employees on attaining a particular age, where their continued utility is examined. Next slide. Resultantly, comma, we, as the opinion dated so and so is found to be initiated by non-application of fine and for non-consideration of the evidence on record. The matter is the impugn opinion dated so and so, passed by so and so and so and so. This is page 65, is hereby set aside. The matter is remanded back for fresh for from the to be taken up from the stage of evidence of the of the DWs. Next para. The next para. At this stage, the learned standing counsel for the FT matters has submitted that he will be allowed to retain the records and send it back, so that the department can that he with the assistance. What do you say, Mr. Payan? You want to examine it? Yes. So as to examine the records and then send it back to the concerned tribunal. Next para. The petitioner, namely Sirajul Haq alias Siraj Jadi, is being represented by his learned counsel, is directed to appear before the learned member from Pardoners Tribunal 9th, Borfita, on 25/3/2020. We're giving you sufficient time, 25/3/2026. And by producing a certified copy of the order, await for further orders to be passed by the said learned tribunal. Next para. In the meanwhile, the learned standing counsel for the FT matters shall return back the tribunal's records to the Home and Political B department. This will take a break and come back.
Pleasure.
Mr. Prime, we don't have any alternative because it's if you want us to be very lenient, then please go through the LCR. If we take the trouble, then yes, this will be coming. Definitely.
Item 4 for hearing.
May it please your lordship. Lordship, amicus curiae is now lex in yet lordship. So it might take time, lordship. One matter is fixed for hearing in cat, lordship.
learned amicus, it has been submitted that the learned amicus curiae is on legs in another court. So accordingly, matter stranger John today, list on, give a date.
Deeply obliged.
Twenty-six. 26.
Item 5.
May I please, your lordships. My lord. My lord, sorry.
There are no documents to prove anything.
My lord,
Exhibit 1 is a Gram Panchayat certificate. Exhibit 3 is 1966 voters list. 4 and 5 are epic. Exhibit 2, I don't know why it has been discarded. There's no exhibit 2. I think that is. What is
my lord,
exhibit?
kindly see the records, my lord. I have seen the record at the record page number 10, 11, and the 11 next page, my lord. Kindly see the
report of the reference referee officer, my lord. My lord, in the next way, 11 next page, it is say LBO's report. There is a remark, my lord. There is an remark sent by the referral authority. Seen the LBO's report, born before 1/7/1987, proceedings dropped. Proceedings dropped, my lord. Please, there is a comment.
No signature. Just pass it on, you will thoughts.
Record.
No signature.
And my lord, the LBO report, it is clearly mentioned that the petitioner was born at Dhubri, Vidyadhari, in 1974. And she has not been suspected to be a foreigner. Nothing. It's a blank report submitted, my lord. There is no, I have taken the plea in the written statement also, my lord. LBO's report, my lord, in my
Yes.
My lord.
Yeah, sending it back.
Well, yes, to be said, no inquiry was done. No inquiry was done. That's done. My lord,
Just for for your, for the purpose of interaction in this matter, you see, this is a verification done by the electoral registration officer. They are not covered by normal determination of foreigners under the Foreigners Act. But there are notifications of the government which says that this is an exercise done under the RP Act, the Representation of the People's Act 1950, Electoral Revision of Roles. And that exercise earlier was done by those references were dealt with IMDT. But after Sarvana Sonwal, in 2005, there is another notification by the government which refers all the matters to foreigners tribunals. So this ground which you are taking, dependent on those cases, recent cases of the Supreme Court, will not help you here.
my lord, one thing I have to submit. My lord, kindly see in my lord, page 38
Of the writ petition.
of the writ petition. This is the LBO report. My lord, petitioner was born in Assam. He is born in Dhubri. And my lord, in 1974. And if the petitioner is not doubted to be a foreigner, my lord, how the reference has been made? Kindly see, my lord, page 39.
That's a doubtful voter. That is the reference under the RP Act. When Mr. Payang submits, he'll tell you in a better way than.
My lord, petitioner is born and brought up in Assam, my lord. How he should be a foreigner, Bangladeshi, my lord? At least specific allegation should be there, my lord.
He will tell you. I think in this, he has something to tell you. He will tell it. Let it come from him.
There is no allegation, my lord. There are so many decisions, my lord, of this honorable court, my lord. I will place one by one, my lord.
Yes. Please give it. You have. So there you are normally prepared. You have this list of citations you have.
My lord, my lord. My lord, my first case is, my lord, WPC number 7517/2017, Saidur Rahman, alias Saidur Rahman versus Union of India. Paragraph 9, 10, 11, and 13, my lord. May I read, my lord? At page 3 of Annexure A, there was the following note seen LBO's report, proceedings dropped, eligible 11/10/1997. Under the circumstances when the contents of the Annexure A of the local verification officer's report, it is mentioned that the proceedings was dropped. There is no record of how the matter came to be referred to the learned tribunal. It is a settled law that the foreigners tribunal would get jurisdiction to render its opinion only when there is a valid reference before it. In the present case in hand, the records does not disclose that there was any valid reference against the petitioner. In view of the note appended to Annexure A of the local verification officer's report, seen LBO's report proceedings draft. Thus, the records do not reveal that there is any material on record to suggest that the petitioner is an alleged foreigner, on the basis of which a reference can be made by the referral authority to the tribunal. A similar view was taken by the coordinate bench of this court in the case of Maimon Bibi versus Union of India and others, WPC number so and so, which was decided on 12/11/2021. In the decision of the full bench of this court, in the case of the state of Assam and others versus Muslim Mondal, 2013 1 GLT 809, it was held at in paragraph 98 thereof that a reference by the referral authority cannot be mechanical. The referral authority has to apply his mind on the basis of which was collected by the investigating officer during the investigation and made the reference on being satisfied that there are grounds for making such reference. The referral authority, however, is not required to pass a detailed order to record its satisfaction, and the record of being aggrieved with the investigation enquiry would suffice. Moreover, it has been held that the referral authority, while making the reference, is required to produce all material collected during the investigation before the learned tribunal, as the tribunal is required to prima facie satisfy itself about the main grounds before issuing the notice to the proceeding. In the present case, the LBO's report by the Annexure A, as well as the form of reference of the Superintendent of Police Border, Dhubri, does not disclose any material regarding the existence of main grounds for referring the matter for adjudication as to whether the petitioner is a foreigner of post 25/3/1971. Moreover, the order sheet of the learned tribunal does not disclose that any exercise was undertaken by the tribunal to prima facie record its satisfaction that the proper reference has been made. Under such circumstances, the court is compelled to allow this writ petition by setting aside the impugned opinion dated 31/7/2017, passed by the learned member, Foreigners Tribunal 10th Dhubri, in application number so and so, arising out of the reference number so and so the case. So, my lord, same view, my lord, in my case of the same thing, my lord. And my lord, in Maimon Bibis also, my lord, I have submitted. This also held the same thing, my lord, same findings, my lord, to Maimon Bibi. My lord. Then, my lord, my lord, I have bring the book, my lord, that is the Anjana 2023 2 GLT 1102, Anjana Vishwas versus Union of India. My lord, I bring the book, my lord, I will photograph, my lord. Two 2023 2 GLT 1102. My lord, paragraph 35 onwards, my lord. Paragraph 35 so onwards, 46, 47 to 49, then 50 to 63, paragraph 72 to 74. 120, paragraph 121, 122, 125, 127. my lord. My lord, paragraph 43, my lord. Paragraph 35, my lord, first stated paragraph 35, Mr. So-and-so that in any event there is a specific mention. There is specific mention in the inquiry report that her father resides in Calcutta and that petitioner was born and brought up in West Bengal. And also there is no indication in the inquiry report that she had come from the specified territory, which is necessary for initiating any proceeding under the Foreigners Act 1964 in the state of Assam. My lord, in my case, my lord, the petitioner in the LBO report, it is stated that she was born in Dhupri and she was born in 1974. So there is subsequent columns are blank. She was not suspected that she had been come to Assam from a specific territory that is Bangladesh, my lord. There is no allegation, my lord, made in the reference. Even not suspected, my lord. Well, kindly see paragraph 43, my lord. In response to the submission, Mr. So-and-so has submitted relying on the decision of Shona Khan that if no proper reference was made, the proceeding cannot be faulted. And if there is no proper inquiry, no reference could be made. In any event, if the proceeding and the had made a certain statement before the inquiry officer, it was the duty and responsibility of the inquiry officer to make necessary verification in that regard. If there was no proper investigation, the proceeding cannot be put to a disadvantageous position, and the authority ought to have accepted the stand of the proceeding that she hails from West Bengal, being born there. In my case, my lord, he is born in Assam. It is categorically stated in our written statement that she was born in Assam, Dhubri, and brought up there. Paragraph 44. To the aforesaid concession, Mr. So-and-so submits that the inquiry report was based initially on the report submitted by the EROs. LBO report make necessary as to whether the name of the proceeding can be continued to be included in the permission. Well, kindly see next, my lord. Paragraph, my lord, 52. From the above, it is clearly evident that there must be proper and fair investigation by the competent authority, inquiry authority. Secondly, the referral authority must apply its mind on the material collected by the investigating officers during the investigation, and only on being satisfied that there are grounds for making such reference, the reference must be made to the tribunal. Therefore, a proper inquiry as regards the doubtful status of the citizenship of a person and proper application of mind by the referral authority on the materials so gathered during the investigation are postulated before a person is proceeded before the tribunal. As a corollary, it would follow that if there had been no proper inquiry by the inquiring authority, no proper application of mind or improper application of mind by the referral authority, or rather a mechanical one, such a reference to the tribunal cannot be considered to be valid in the eyes of law. The natural consequence which will follow is that if the reference had not been validly made, the proceedings before the tribunal would be vitiated. Then, my lord, paragraph 55. the verification officer's report as available in the record, the relevant facts have been mentioned. To understand this properly, the scanned copy of the verification officer's reports is produced here below. My lord, the same thing, my lord, in my case also happened. Blank paper submitted, only the name and the place of birth, and no documents, nothing, no comments in the subsequent columns, my lord. Paragraph 56. Perusal of the aforesaid verification officer's report clearly indicates that the inquiry officer had noted at serial number 5 of the form that the place of birth of the petitioner is West Bengal. It has further noted that at the serial number 13 of the form relating to inquiry officer assessment on the direct spoken dialect spoken, it is specifically mentioned that her father resided in Calcutta. So she was unable to provide documents within sufficient time. It can be seen in respect of their entries required to be made, these have been left unfilled. In this regard, one may refer to serial number 15, which relates to information as to whether migrated into Assam with the remark yes or no, but nothing is mentioned under that head. Similarly, in the subsequent serial number 16 as regards to the column if yes, plus from where migrated, it is again kept unfilled. Similarly, in the respect of serial number 16 to whether migrated before 1166, between 1166 to 24,371 or after 23,571, the same has been also kept unfilled. However, on the basis of the said verification officer's report, which does not indicate at all that the petitioner is an illegal migrant but hails from West Bengal, the ERO made the observation that he had a reasonable doubt that the proceedee is not a citizen of India and accordingly forwarded the matter to the Superintendent of Police, Moregaon. The scanned copy of the ERO reports, it is given, my lord. Then, my lord, my lord. So, my lord, my lord.
My lord, in item number 9, can I peruse the ECR?
I do not.
My lord, paragraph 120 of my lord Anjana Vishwas case. 120 paragraph. In our opinion, when such a plea is taken that a person hails from another part of this country and not from Bangladesh, such a plea must be considered with utmost seriousness, inasmuch as the tribunal will have any jurisdiction to consider the claim of any person who does not hail from specified territory within the meaning of Section 6A of the Citizenship Act 1955. In this regard, we may refer to the decisions of the Indira Newar's case and a batch of writ petitions wherein a number of proceedings against persons belonging to Nepali community, but ultimately, my lord, it was observed in Indira Newar's case that in respect of a proceedings before the tribunal constituted under the Foreigners Tribunal's Order 1964, having jurisdiction over a district or part thereof in the state of Assam, in terms of Rule 21 Citizenship Rules 2009, the primary and necessary ingredients or the condition precedent is that the reference can only be in respect of persons who have come to Assam from the specified territory, meaning the territories included in Bangladesh immediately before the commencement of the Citizenship Amendment Act 1985. And also having regard to the cut-off date of migration into Assam and prescribed under the Section 6A of the Citizenship Act 1955, 122. It was also observed that Indira Newar's that if no suspicion is expressed by the referral authority or in absence of any finding recorded by the concerned authority that any of the proceedings are persons who had come into Assam from the specified territory, such a proceeding will not lie. Though though in the said batch writ petitions, the matters related to the members of the Gurkha community who originally hailed from Nepal. Then, my lord, 125 paragraph. In our opinion, the same principle will be applied to other persons who have not come from the specified territory. In the present case, the petitioner claims that she came from West Bengal, which is not part of the specified territory, which refers to the territories in Bangladesh immediately before the commencement of the Citizenship Amendment Act 1985. Thus, West Bengal being not part of the specified territory, but a part of this country, no proceedings should be lie against the petitioner before the Foreigners Tribunal. My lord, my humble submission before your lordships that in the LBO report, my lord, petitioners found that he was born in Dhubri and then she was not suspected that she will be came into from the specified territory. There is no allegation. So, my lord, that reference is the mechanical reference, my lord, and could not be acted upon on the basis of that, my lord. And the impugned order passed, my lord, totally a non-application of mind on the part of the land tribunal below, my lord. Then, my lord, was Sushil Mondal's case, my lord, 2022 1 ZLT 790 page. Paragraph 5, 6, 8, 9, and 10. Two 1 GLT, page 790. Sushil Mandal versus Union of India. I'm sorry, I have one copy, my lord. Paragraph 5, my lord. We have perused the original records requisitioned in this regard and also seen the enquiry report as contained in Form 1, paragraph 21, Form 1, which relates to the enquiry officer's final finding. It has been recorded by the enquiry officer as follows. During enquiry, it appears to me that suspected Sushil Mandal, son of late Pashan Mandal, is not an illegal migrant who could produce sufficient valid documents in support of his nationality. Hence, the case is forwarded through proper channel to the Honorable Foreigners Tribunal for opinion judgment. The aforesaid final finding was also by the enquiring officer. Thus, from the above, it is very clear that the enquiry made in respect of petitioner, there was a specific finding that he could produce sufficient valid documents in support of his claim of Indian nationality, and accordingly, the enquiry officer recorded the finding that he is not an illegal migrant. In our opinion, under such circumstances, the question of referring the matter to the Foreigners Tribunal does not arise. In our view, a reference can be made to the tribunal for determining whether the proceeded is a foreigner or not, only when a doubt arises about the nationality of the person concerned, or when there is a specific finding by the enquiring authority that the proceeded is suspected to be. Paragraph 6, my lord, I am reading. In our opinion, a reference can be made to the tribunal for determining whether the proceeded is a foreigner or not, only when a doubt arises about the nationality of the person concerned, or when there is a specific finding by the enquiring authority that the proceedee is suspected to be a foreigner, contrary to the claim made by the proceeded that he is an Indian. Thus, when a question has arisen as to nationality of the proceedee, obviously that requires to be resolved by a competent neutral forum, which has been provided under the Foreigners Order 1964 by creating the Foreigners Tribunal to determine this issue. It has been provided under Order 2 of the Foreigners Tribunal's Order 1964. The central government may make an order for constitution of Foreigners Tribunal for the purpose of its opinion as to whether a person is or is not a foreigner within the meaning of the foreigner. The aforesaid provision, however, does not mean that any reference can be made even if there is a finding that a person is an Indian. If a person claims to be Indian and the enquiring authority, after necessary enquiry, also holds that he is an Indian, it cannot be said that there is a dispute or any controversy as regards the nationality of such person, which requires reference to the tribunal as a need for determination is not there. The Foreigners Tribunal, which has been created in terms of the Order 1964, is meant to give its opinion only when there is a dispute or doubt about the nationality of a person. The question of referring a matter to the Foreigners Tribunal does not arise when no such dispute or doubt exists. The purpose of constituting a tribunal is to decide the nationality of a person when there is a doubt or dispute about it. Paragraph 9. Paragraph 8, a valid reference can be made by the referral authority only on the basis of certain finding which has been arrived at by the inquiring officer. In the present case, a valid reference can be made by the referral authority only on the basis of certain finding, which has been arrived at by the inquiring officer. In the present case, the inquiring officer has given a finding that the proceedee is not a foreigner. Under the circumstances, the referral authority could not have referred the matter to the Foreigners Tribunal for its opinion. If the referral authority does not agree with the finding of the inquiring
This will
officer,
not be applicable. He will give you that argument.
well,
Because this is by reference by an ERO. ERO only this 52 and 55 of the earlier judgment in this Soidur Rahman. So not that. Anjana Biswas, there is a reference. But there is a judgment which says otherwise. He'll show that. So
My
it
lord.
says otherwise. That is
Well-
why this case of Sushil Mandal doesn't really help you.
my lord, my contention is that the petitioner, before referring Mandal, my lord, allegation should be there that that person come from the specified territory, or he is suspected to be foreigner, my lord.
I'm just
And that, my lord, if that is not there, the foundation is not there for trial, my
we
lord.
respect these orders. We are not
And,
saying that is
And
no, no.
all this, my lord,
Today-
judgments
today-
reflects
today
that, my
We
lord.
are not saying these orders are wrong, but I have a query. Now, you go out from here and in the road, somebody pickpockets you or somebody else. Police comes, arrest this person and then tells him, are you a pickpocket? He says, no. Police records his statement, interrogated the accused person. He denies that he's a pickpocket. Then what? Statement is recorded. He
My
gives
lord-
a statement, police truthfully records that the X has, there's a pickpocket of X. This man was caught red-handed. He gives
Yeah.
a statement that he is not a pickpocket.
But my lord, the permanent address should be there, my lord.
So that's why we say that How would you deal with it in these circumstances? It's the evidence. Three people have seen that this man has done the pickpocket, and therefore that evidence will override. We are not saying these judgments are wrong in any description. We are not even suggesting that. I'm just asking a query. What happens? In a civil suit, somebody grabs land. That's an affidavit that no, I have not grabbed the land.
My lord, my lord, all this, whatever, my lord, I am submitting, my lord, these are all are related to related to my case also, my lord.
No, we are
Because,
not
my
saying-
lord, same, we are in the same footing, my lord. Same footing.
saying this, we are not suggesting this judgments are incorrect. We are asking just,
Already, my lord, this honorable court settled this.
no, we see that. And you have referred to this Rahim Ali and Amina Khatun for what?
Yes, my lord. Amina Khatun also it is supported my case. Then, my lord, Roshana Begum, my lord, in a brother's evidence, in my case also, my lord, on brother examined, my lord. Our brother examined and said that he is my sister. But his evidence was not, his evidence was discarded because he's in the voter list, voter ID card, his father's name is recorded as, my lord, Mofiz Mia, Mofiz Ali Mia,
Mofizuddin Mia.
Mofizuddin Mia, Mina. Actually, my lord, Assamese version is Mia, written as Mia, but in the English version, it is written as Mina. It is a spelling mistake, my lord. For that reason, my lord, his brother's evidence has been curtailed, not, they hold that it is not trustworthy. Kindly see, my lord, that evidence. His brother's voter ID card, my lord, page 58 of the writ petition, exhibit 5. Exhibit 5, my lord, in Assamese, Mofizuddin Mia. But in English, it is written as Mofizuddin Mina. And the learned tribunal has, my lord, interpreted this name. Though he categorically stated in his WS, Mofizuddin, my lord, Asfar, the answer, Hasan Ali, my lord.
You know, interestingly, on facts, if you read your written statement and the evidence on affidavit,
My lord.
you have never introduced your brother.
My lord, DW2, Annexer I, page 52, he categorically stated that his father's name is Mofizuddin Mia, alias Mofizuddin Sheikh, alias Mofizuddin. And paragraph 2, he stated that the present proceedee is his own sister. Paragraph 3, I am a citizen of India. My lord.
You are reading at page? You are reading at which page?
Page 52, my lord.
52, okay.
52. I, Hasan Ali Sheikh, aged over 68 years, son of late Mofizuddin Mia, alias Mofizuddin Sheikh, alias Mofizuddin. Then, my lord, paragraph 2, that I know opposite party, the present case, and she is my own sister. Then paragraph 3, I am a citizen of India by birth. My father's name is Mofizuddin Mia, Mofizuddin Sheikh, alias Mofizuddin, and my mother's name is Asia Bibi Asimon Nesa. Earlier, we were the resident of Sotopokalagi under PS Golakganj in the district of Gwalpara, now Dhubri, Assam, where I was born, and being the resident of village Chotopokalagi, my name has been entered in the NRC of 1951 as Hasan Ali Sheikh, along with my parents now deceased by number so and so. The 1951 NRC, his name also there, his father's name also there in the NRC, 66 voter list also there. We are four brothers, and namely Hasan Ali, myself, Amjad Ali, Asfar Ali, Abbas Ali, and two sisters, namely Mojida Bibi, now deceased, Momina Bibi, the present OP of case who was born and brought up the village Belguri Part 1. Then paragraph 6, after attaining majority opposite party, my sister was married to one Maqbul Hussain, son of Shirazul Haq, resident of village Biddardabi Part 3, PO Biddardabi under PS Gulabganj in the district of Dhubri, Assam. And since the date of their marriage, the opposite party, my sister, has been residing at her matrimonial house of above address. That it is not fact that opposite party Momina Bibi is not my sister. It is not a fact that OP is not citizen of India. Then, my lord, kindly see the findings of the learned tribunal, page 63. Page 63, last portion, my lord. Last few lines. 7th line, my lord, from bottom, DW2 namely.
This, coming back to your evidence of DW2, he has not exhibited any document.
He exhibited two documents, my lord. At a one NRC details, page 61, my lord. And voter ID, that is page 58.
Voter ID we have already held in many cases that voter ID is not a proof of.
Then the NRC, my lord, and
which was not proved. It is annexure A, page 52.
Page 52.
Annexure A is the NRC of 51. It is not an exhibited document.
Exhibit 5. Exhibit 5, my lord, voter
Yes,
list.
voter ID,
Voter ID.
prepared in 2013.
And the NRC, my lord, legacy data annexure A. That is NRC, my lord.
So that is not
Page-
exhibited document.
Page 61.
That is not an exhibited document.
And my lord, his father's name. So, my lord, finding of the landed tribunal, my lord, kindly see page DW2, page 63, last few lines, 7th, bottom from bottom 7th line, my lord.
Yes.
DW2, namely Hasan Ali, who stated that he is the sister of OP and exhibited one electoral photo identity, exhibit 5, card number so and so, whereby shown the village, Sagolia Azkhana, Kanda, 25 Gulabganj, found his father's name Mofizuddin Mina. Now, the OP stated that her father's name is Mofizuddin, as per the exhibit 1 and in the voter list of 1966, exhibit 3, found that the same name as Mofizuddin of village 100 Belguri Part 1. When the perusal of the photo identity card exhibit 5 found the father name Mofizuddin Mina name is different. Hence, the evidence of DW2 as well as exhibit 5 is not trustworthy. So this is the finding, my lord. There is a spelling mistake, Mina. It is written Mina, Mia. So that's why it is held that it is not trustworthy. My lord, that is spelling mistake, and the Assamese version is correct. So that should not be a ground to reject this, the evidence of DW2. And the moreover, my lord, is categorically stated that the DW2 is the blooded related brother, my lord. And DW2 stated that his OP is the sister, his own sister. Otherwise, my lord, from 66, his father's Mofizuddin, grandfather Ketab Sheikh. Asia Bibi is the mother, is reflected. Then in 1997 voter list is there, petitioner's name is there with her husband, Momina Bibi with Maqbul Hussain. And since then, my lord, onwards, his name is existing in the voter list.
Yes.
My lord. And the Roshana Begum's, my lord, brother's evidence, my lord. Paragraph 7 and 8, my lord. Paragraph 7 and 8. It is settled that whenever a decision-making authority takes a decision, it is obligated to take a consideration all the relevant facts and materials. And if any relevant and material facts or material has not been taken into consideration by the decision-making authority, the said decision arrived at cannot be considered to be valid inasmuch as it will be vitiated due to non-application of mind on an important material or evidence. It will be equally true of a decision rendered by a foreigners tribunal which is quasi judicial body. In our opinion, evidence of DW2 will be highly relevant and material in as much as the issue before the tribunal is to determine the citizenship of the person petitioner relating to which the evidence of our close relatives become highly relevant and material. Accordingly, we are of the opinion that the learned tribunal, having not considered the evidence of the projected elder brother of the petitioner, its opinion would stand vicious. The brothers related, my lord, brothers evidence is materials, my lord, should be believed, my lord. Discarding due to spelling mistake, that cannot be a ground, my lord, to reject the entire evidence of the brother, my lord. Otherwise, also, my lord, she is stated that in her WS, that is, she is born and brought up in Dhubri, my lord. Paragraph 3.
But why, while writing written statement, she would forget her family? Brothers are not introduced. And this witness, TW2, your
My
brother,
lord.
please read his cross-examination. He perhaps says that he has not produced any document to prove relationship.
DW2, I am reading, my lord, the type copy, my lord.
Read
Type
the
copy,
vernacular,
page 55.
read the vernacular, that will be better. Okay, read type 1, no issue with that.
Page 56 is the, my lord, handwriting copy. And
Yes.
55 is the type copy, my lord.
This is not very readable.
My name is Ahsan Ali, son of late Mofizuddin Mia. By caste, he is Muslim. My age is 68 years. I reside at village Sagolia, Part 2, police station, Golagganj, district Dhubri, is occupation cultivator. I am read up to class 3 at Sagolia LP school. I do not know the year. My date of birth in the year 1948. It is OP is my own sister, and she was married about 20 years. Husband named Mokbul Hussain. I have not submitted any document regarding OP is my sister. Otherwise, my father name is Mofizuddin Mia. My father was born at village Choto Pukalai. So, my lord, he categorically stated OP is his sister, and his father's name is Mofizuddin Mia. Mofizuddin. The Mofizuddin and Mofizuddin Mia, Mofizuddin Sheikh is the same person, my lord. My lord, it is in the cross-examination, whatever he asked, the cross-examination, he has answered. And there is nothing adverse against the OP, my lord. Now, in the writ petition, my lord, it is stated that how many brothers and sisters he have. But in the WS, my lord, it is not there. But due to better writing, my lord, it depends on the advocates, my lord, who are engaged with petitioner. That is another issue, my lord. For that, my lord, the petitioner should not be suffering. And the evidence already, my lord, comes before the court, my lord, before the tribunal. It is also proved that she is the sister of the DW2. Because in the cross-examination is there, and the cross-examination is affirmative. There is no denial that she is not the sister of the DW2. All the finding of the learned tribunal is that the only father's name is, instead of Mofizuddin Mia, it is written Mina. Mina is the spelling mistake, my lord. In the Abdul Rahim's case, my lord, it is clearly stated that mere spelling mistake should not be a ground to discard the entire evidence of the petitioner and the DW.
Sonali. Sonali Sheikh. Hasan Ali alias Hasan Ali Sheikh. Saman Nasa, my lord, his mother's name, nickname, my lord. It is sometimes called so and so. Saman. It is stated in DW's evidence. Actually, Asia. Asia is Asiman.
So, my lord, my humble submission before your lordship that the impugned order dated 39/2016 is liable to be set aside, my lord, due to statements as stated above, my lord. I have stated. And the supporting citations, my lords, the impugned order is liable to be set aside. Paragraph 4. Last line, paragraph 4. My lord, page 46, 51. My lord, 1 minute, my lord. 51. 51, my lord, the handwriting. 53. 53.
Page 53. 53.
53. Paragraph 53. Paragraph 4. Well, I'm reading the paragraph. Almost at the time of 8-9 years ago, our residence was shifted to Belguri Part 1 under Shindurai Gaon Panchayat at the house of the one Shaidur Rahman, son of Hafizur the Box from the village Chotopukalagi, and being the resident of the village Belguri Part 1, my parents have been enlisted the voter list 35 Gulabganj Sele constituency, 66 byte part number Iman, respectively under house number 6, exhibit 3. And we resided there until till 24 years ago. And we again shifted to the village Sagolia, part 2, under Gulabganj police station until date where I am residing. So, my lord, his brother, Opis brother, petitioner's brother shifted to Sagolia. But I am not following his lordship. Kindly excuse me, my lord. Oh, my lord, yes. We shifted. Exhibit 3. His parents' name enlisted with a list of the respectively under him. We are resided there until my lord, perhaps it is related with referred to his parents, maybe, my lord. Parents. Here I go. S20, and we again, yes, with his parents, my lord, Sagolia. And in the meantime, my lord, in 97, his sister was married, and she shifted to Viddardarbi, husband's home, with Mokbul. My lord. Brother shifted. Is not clear, my lord. My lord, in paragraph WS evidence. Paragraph 6. Hi, yes. After 1951 or its later, my father Mofizuddin shifted his residence from Sotopokalagi to and settled Belguri Part 1 at the house of Shahidur Rahman, son of Haji Ayajan Box, with my mother Ayesha Bibi, and accordingly in the year 1966, my parents' name Mofizuddin and Asia Bibi have been enlisted in the voter list so and so, so and so. With respect to village Belguri Part 1. Exhibit 3 is the copy of the voter list 66. After marriage and being resident of village Vidyadhavi Part 3, PO Vidyadhavi under PS Golokganj in the district of Dhubri, my name has been entered in the voter list 25 Golokganj LSA constituency 1997 by the part number application. So accordingly, in the year 2013, an electoral photo identity card was issued. My name has been continuously been enlisted in every voter list, and lastly in the year 2016, my name has been entered in the voter list 25 Golokganj, serial number so and so, and Excel 5. Fathers. Another village.
At that time, it was 21 years. At that time, it was 21 years. In 1969. 69. 71 names would have been there. 71.
That voter list
That
has
is
not
not
been given.
existed.
Since, my lord, the case is against the OP, my lord, so, my lord, DW2 has not given the entire voter list in one given evidence. It's just come and he to establish the linkage with his father. That is, he is my sister and my so and so to my mother, father and parents. That's why, my lord.
Yes. Yes.
আছে নে কপি আৰু
Seventeen. My lord, 17, I have another matter, a hearing matter, my lord. 19. 17, 19. 19. Can it be, my lord, on 25th? Or 24, my lord? 24.